it comes to benefits, the smallest details can cost your company big. Knowing how to read your certificates of coverage and policy documents isn't just a skill, it is your safeguard against costly mistakes and compliance risks. Today, we will walk through exactly how to break down these dense documents so you can protect your employees and your business, because understanding the fine print could be the key to unlocking better benefits and avoiding compliance pitfalls. The purpose of a certificate of coverage, also sometimes called an enrollee certificate or a certificate of insurance, is to provide information to covered members about the coverage under the policy. What the certificate of coverage is not is the policy document. The certificate of coverage is drafted by the insurer. It is directly speaking to the member and their benefits. This is issued and mailed by the insurer in the case of a fully insured policy. And in the case of a self-insured policy, oftentimes the certificate of insurance will be replaced, and what would be provided would be the summary plan description, which is often provided by the third-party administrator in conjunction with the self-funded plan sponsor or the employer. When we're looking at the certificate of insurance or the certificate of coverage for a healthcare policy, it is very helpful in understanding what the policy covers. With the implementation of the Affordable Care Act, a summary of benefits and coverage document is required for all healthcare policies. And the reason for this was so that individuals could have a universal document that they could use to compare coverage types and options for specific types of coverage. So for example, a summary of benefits of coverage is going to have information about your deductibles, your coinsurance, your out-of-pocket maximums. It'll have information about primary care and urgent care, emergency care, facility services, mental health services, etc. However, the summary of benefits and coverage does not have sufficient information for individuals to fully understand their coverage. And that is where the certificate of insurance is very helpful, because that certificate of insurance is going to list definitions, which are crucial to interpreting coverage, as well as additional information on exclusions and policy limitations. And it has a deeper dive into other types of coverage that might not be listed on that summary of benefits and coverage, such as chiropractic care, whether that is covered, whether acupuncture is covered, and some additional information about the allowed amount under the insurance plan and how that is all determined. The policy document, contrary to the certificate of coverage or the certificate of insurance, is written for the plan administrator, i.e. the employer, the plan sponsor. The policy document is going to have some information about coverage, but mostly the policy document talks about when is the premium due and what are the terms under the plan, what would constitute a breach or cause the policy to terminate, as well as some just additional information about the policy in general. It is not information for the member who's seeking coverage. The policy document is a document that is geared more towards the employer or the plan sponsor. It's a common misunderstanding that the policy document and the certificate of coverage combined would fulfill the requirements under ERISA for a summary plan description. Not true. For the vast majority of cases, specifically for fully insured plans, the policy documents and the certificate of coverage documents, even combined, do not address all of the stipulations under ERISA that are required to be included in a summary plan description. Therefore, many employers will work with either their broker or a third-party vendor to draft these summary plan descriptions on their behalf in order to meet the legal requirements under ERISA. What is a commonplace practice for these documents is for a wraparound summary plan description. What a wraparound summary plan description does is it combines multiple policies and documents into a single document. It wraps around the other documents that are prepared by the carrier or the insurer, such as the certificate of insurance and the policy, and all together combined would equate to the summary plan description. This can also be useful for employers that are required to file a Form 5500 for multiple policies, because a wraparound A summary plan description can include multiple policies in one document. So for example, it could include the healthcare plan, the dental plan, the vision plan, and life insurance all in one document so that only one Form 5500 filing would be required. What's also important to note is that if you only have one plan that has 100 or more participants and would be required for a filing, if you have a wraparound document that includes all of your plans, then you would also be required to file a Form 5500 for all of those plans, even for those that didn't have at least 100 participants as of the start of the plan year. Therefore, when employers are working with their broker or a third-party vendor to draft these documents, it's important to consider how many individuals are enrolled under each plan and whether or not the employer has a Form 5500 filing obligation. You can always amend these wraparound plans to exclude different coverages in order to make that Form 5500 filing simpler. So for example, let's say that you had at least 100 enrolled in the group life insurance plan because that covers every full-time employee. However, not everybody has opted into the health plan or the dental plan. So only the life insurance plan is required to be filed under a Form 5500 with the Department of Labor. In that case, an employer may decide to have a wraparound SPD for the life insurance policy to satisfy those summary plan description requirements and then file one Form 5500 and then have a separate wraparound summary plan description for all of their other group health plans, the medical, the dental, the vision, etc. Why does this matter? Why do you need to know about these different kinds of policy documents? Well, a lot of reasons. One, it protects you from any compliance pitfalls. If the Department of Labor were ever to conduct an audit and want to review this information, they're going to look for compliance with ERISA, with the Affordable Care Act, with HIPAA, et cetera. You would get an investigation letter from the Employee Benefits Security Administration, and they're going to have a list of all of the different documents that you're required to have and whether or not each of the documents has all of the language that is necessary to be included in these documents. They're going to want to ensure that these documents have been distributed as they're supposed to. So that's number one, compliance is the main issue, but also to answer any coverage questions. Individuals have a right to understand what is covered under their policy, what is excluded from their policy, and to be able to get answers to these questions. And then it's helpful to be able to compare what is and isn't covered when you're making a decision for all of your employees and their coverage options. It's useful information to know what different insurers cover and don't cover, what is and isn't standard, and additional options that could set your company apart and help you be more competitive with your benefits package. Different types of insurance coverage have different information in their certificates of coverage. So when we look at a healthcare plan, for example, it is going to have information that's similar to all certificates of coverage, such as, who's covered and what is excluded. However, what a healthcare plan cannot have today would be pre-existing condition limitations, and that is due to the Affordable Care Act, where they have removed pre-existing condition limitations from healthcare policy. What a pre-existing condition limitation is, exemption from the policy to exclude from coverage anything related to a condition that was treated during a 12-month period prior to the implementation of a policy. A healthcare plan can't have this in place, but life insurance policies, disability policies, dental policies, they can still have some pre-existing condition or treatment limitations within those policies. If we look at a dental policy as an example, it is very common for a dental policy to have a limitation to not cover more of the advanced procedures, such as root canals, unless the individual member has been covered under a dental policy for at least 12 months, or for the individual to not have had a gap in dental coverage for a specified time in order to provide that coverage. Similar, if you have a dental policy that has orthodontia coverage, there's often a limitation in that policy as well, saying that the individual who's covered either has to have had orthodontia coverage on a previous policy during the last 12 months or have coverage without a gap in coverage. So they couldn't have had a loss of coverage for longer than 60 or 90 days, depending on the policy, in order for them to be able to use the coverage in their current policy. It's very common for disability policies to have pre-existing condition limitations, saying if you've been treated for a specific illness or injury within, it's usually 12 months prior to the effective date of your policy, then you would not be able to be covered under your current policy for a disability or an illness or an injury that you already had and were treated for in the previous 12 months, unless you've been paying premium on your policy for at least 12 months or you had a previous policy. And that's important to know because it's important for individuals when they're making their policy choices to choose appropriately. And that information should be clearly communicated to employees so that they know what they're getting into when they sign up for a policy. Eligibility criteria for dependents is another big one. For a health insurance plan, there are many plans that, even though they include coverage for dependent children, there might be limitations on the coverage provided. The Affordable Care Act has allowed children to be covered under their parents' plan up to age 26. And the Affordable Care Act does consider pregnancy and maternity coverage an essential health benefit. However, there are many healthcare policies where pregnancy-related benefits would not be covered for a dependent child in certain circumstances, such as if they were married, or they just might not cover pregnancy or maternity-related coverage for a dependent child at all under any circumstances. And that's important to be aware of because if that's the case, if somebody is covering their child under their policy who is under age 26, but then that child gets pregnant, they won't have maternity coverage under that plan. And then their options would be limited as far as getting other coverage, either on the exchange or through Medicaid, if they were to qualify based on their financial situation, because they already have other coverage in place. It's just that their coverage does not cover what they need. That's why it's very important to get your hands on those certificates of coverage and be able to review what is and isn't covered and help your employees understand so that they can make an informed decision during open enrollment. Common clauses that you need to pay attention to, in addition to coverage limitations and exclusions based on the definitions in the policy, would be coordination of benefits rules. Prior to the implementation of the Affordable Care Act, it was very popular for individuals to have double or triple coverage, meaning that they had more than one health plan or more than one dental plan, thinking that that would give them more coverage for medical or dental. And in a lot of cases, that used to be true. Today, however, it's not so much. The way that policies coordinate benefits with each other, even if you are covered under two health plans, the two health plans together are not going to pay more than the allowed amount under both policies. So it's really not going to cover those additional expenses that individuals think may be covered if they pay double premiums. Oftentimes what happens is it ends up just being more expensive because they're paying premium for more than one policy, and both policies combined will never pay more than the greater allowed amount between those two policies. And members are still going to have out-of-pocket costs regardless. Double coverage just really does not make sense when it comes to health plans today. Even dental and vision plans, it is very, very common to have coordination of benefits rules. And when we look at disability plans and policies, they also have coordination of benefits rules. And an individual might think that they're going to get more coverage if they have an individual short-term disability policy outside of work and then a separate short-term disability policy within their work. And that's not the case because the two policies are going to coordinate together and they're never going to pay more than a certain percentage of their earnings as defined under the policy. So it's important to find those coordination of benefits rules and understand how they work to help your employees navigate that. Premium contributions, who pays and how much. That information is typically listed in the policy document. That is important to pay attention to. Carriers have specific rules, and you can get different price points for premium based on whether you pay 100% of the premium for your employees or there's a cost sharing arrangement. And because they are structured to pay that way, it's important that you adhere to those rules within the administration of the policy and the collecting of premium. Termination and renewal clauses. That information is also going to be in your policy document, and it's important to pay attention to those things as well, because that is going to help you understand how you're going to renew that policy and when, and what stipulations would constitute a non-renewal of that policy. And then reading between the lines can be very helpful because then you can identify vague language or terms that could lead to confusion, either your confusion, which you want to get some clarification on prior to the purchasing of a policy, or confusion on behalf of your employees. It's common for employees to have a lot of questions, and they might not ask you if they don't feel that you would be able to answer those questions, or they might not be comfortable because they may feel like asking a question is a show of ignorance, and they don't want to do that. So it's very helpful to have that opportunity to understand the policy yourself and have a meeting and be able to explain that information to your employees during open enrollment. And then it's helpful to cross-reference the summary of benefits and coverage for consistency with the certificate of coverage. These documents are prepared by the insurers and the carriers, and they are prepared very carefully, and they go through a quality assurance process and an audit process. But at the end of the day, these policies are being drafted by people, and people make mistakes. Errors can occur even after a policy has been published. So if you do find a mistake or discrepancy between the summary of benefits and coverage and the enrollee certificate or certificate of coverage, then that's very important to bring that to the attention of your broker so that your broker can work with the carrier to get the policies corrected, and also to communicate that information to all of your members who are covered under the policy. And then when you read between the lines in your policy documents, you can often see red flags, and you can have a good sense of what to look out for and avoid any potential compliance issues or unexpected costs. HR professionals really should review policy documents before open enrollment so that you have the information that you need to provide to your employees so that they can make informed decisions when it comes to those policies that they're going to select during that open enrollment period. You should understand how to explain those benefits to your employees when any questions should arise. And then also HR professionals really need to know how to consult legal or benefits advisors for clarification on any policy terms or information that might be unclear. As a fiduciary of your plan, you will be the last step in the event that an employee appeals a decision on the plan. And so as the self-funded employer who is the plan fiduciary, it would be your responsibility to read between the lines in the policy and determine whether something should or should not be covered in response to that appeal. And it's very important from a legal perspective that all of those appeals are handled in the same form and fashion so that you are not being discriminatory and that the plan document rules are being adhered to. Making sense of your benefits documents doesn't have to be overwhelming. Once you know what you need to look for, you can ensure that your employees are getting the coverage that they expect and your business will stay protected. Remember, the more that you understand about these benefits documents, the better equipped you will be to make informed decisions. Thank you for watching. Don't forget to subscribe for more insights or navigating employee benefits and compliance. And let me know if there's something that is important to you, because I want to make sure that I'm providing information that is of value and interest to you. So please leave me a note in the comments and I can work on providing further information or clarification in another video.